Right, I think we'll make a start. So good morning, everybody. I hope you're all well. My name is Amy Stokes and I'm a senior associate and I lead on business immigration and at Forbes. I'm also an employment solicitor as well. And with me today, I have my colleague, Charlotte Black, who is a paralegal working with me closely in the business immigration team and also in the employment team. I'm sure a number of you on the session today will have come across Charlotte in the past, and she's a font of knowledge in relation to, she's laughing, in relation to right to works checks and business travel as well. We have a lot to get through this morning. There is a great deal of content and a lot of the information is on the slides. We will be circulating the slides afterwards, so don't feel that you need to take copious notes. And I've tried to, a little bit differently from the normal session, I put a lot more information in the slides today so that there are some takeaways for you because some of it is very technical. In terms of the Q&A, I know that everybody was given the opportunity to submit some questions ahead of time, and we've had some really great questions, and actually we've built a lot of the answers into the session today, so hopefully we should deal with those as we go through. I've pulled out a couple of questions from that we'll talk about right at the very end, but if you do have any more questions, then please pop them in the chat function as we're going through, and then we'll deal with them at the end. There'll be a bit of time at the end to get through that. There were some questions in relation to kind of more specific situations, and I'll obviously take those offline as well. So just to start off, in terms of the agenda and what we're talking through today. So we're mainly going to deal with the new immigration rules from the 1st of January. That'll be the first point of the session today. Then we'll talk through a little bit about recruitment of non-UK nationals after Brexit, so after the 1st of January, and what that might look like and the options for that. We'll talk about sponsorship licenses, whether you need one, what a sponsorship license looks like, what the requirements are as well. And then we'll talk about, and I know there was a lot of questions about this, about what rights do existing EU staff have and what steps should employers and employees be taken. So this relates mainly to the EU settlement scheme. In addition to that, then we'll move on to the right to works checks and take you through the requirements for that, how the changes have affected that and how Brexit has impacted that in relation to the EU settlement scheme. Charlotte's got some great hints and tips there as well about what you should be doing as a business from a practical perspective, managing your right to works checks at that stage. Then we're going to take you through how the new rules and the ending of free movement of people, how that impacts on business travel in the UK. So quite a bit to do, but it should all be very interesting and hopefully relevant to your business. So to start us off, I'm just going to take us through a bit of a summary of the changes to the immigration rules from the 1st of January. As you can see from the slide, and as you all well know, the UK left the EU on the 31st of January 2020. Then we entered into this transition period during which nothing changed. That ended on the 31st of December last year, and the rules governing the new relationship between the EU and the UK took effect from the 1st of January 2021. And that vitally for this session included the ending of free movement of people between the UK and the EU. There are now different rules and new rules that apply to business travellers and workers from the EU, and that includes the EEA in Switzerland to the UK and vice versa. New EU travellers to the UK and UK arrivals from the EU from the 1st of January will need a visa to work. And each country has its own distinct rules on these visas, and that's where it becomes very, very challenging because Charlotte and I have been asked by clients on a number of occasions about requirements in different countries. And there is no one size fits all if you're traveling abroad. There are certain countries that have kind of signed up to similar type rules, but in reality, if you do need a worker visa for a business travel or in general, there are different and distinct rules for each country. That is something that we can advise on to an extent, but it may well be that you need specific advice, immigration advice in each different country. So it does present a challenge to organisations and an additional cost and various hurdles to jump through if you're looking at business travel or if you're looking at placing employees abroad. In addition to that, when we talk about business visits, and Charlotte will go into this later, they need to be limited to those activities that are permitted by each particular country. So Charlotte will take you through that a little bit more later. EU nationals in the UK and UK nationals in the EU who arrived on or before the 31st of December 2020 can remain and secure their status here. So that's via the appropriate scheme. So the appropriate scheme, as you know, in the UK is the EU settlement scheme, and the deadline for that, for applying for that for individuals who were here prior to the Brexit, end of the Brexit transition period, is the 30th of June. And we'll talk about the specifics for that and right to work checks and requirements as we go through the session today. And if you have any UK nationals placed in the EU, there is action required, and the deadline for that does vary by country. I've got a really interesting and useful chart that has different deadlines in EU countries for looking at their own settlement schemes. So if anybody is interested in that, just drop me an email at the end and I'm happy to share it with you. I was going to put it on the screen, but it's really complicated, and so it makes sense to have it as a separate document. Just to add to all of this, at the same time as the end of the Brexit transition period, there was also a complete overhaul of the immigration system in the UK, and we're now operating on this and what's been billed as the points-based immigration system for skilled workers who want to come over and work in the UK after the 1st of January of this year. So a summary on the immigration changes and the new rules, the new immigration rules. So the new rules aim to treat EU and non-EU citizens who want to live and work in the UK equally. And it aims to attract people who can contribute to the UK's economy. The key point here is that the focus is on attracting highly skilled and skilled migrant workers to the UK, which unfortunately means that there is no route for low-skilled workers. This has presented a huge challenge for those employees, and I know that a number of you are on this session today who heavily rely on EU workers for these low-skilled jobs. The impact is being really felt and will be widely felt after we get through this COVID situation, and will be highly felt in the hospitality sector, also in manufacturing, farming and agriculture, but also the healthcare sector as well, that historically rely on these EU workers to do the lower skilled work. The vision, the Home Office vision and the government vision is that previous work done by these low-skilled workers will be done by the resident workforce. This was an aim of Brexit. This was one of the reasons that a lot of people voted for Brexit, so that more jobs for the resident labour workforce. And also, they also are saying that they will no longer be required due to greater efficiencies and automation. I know this has pushed a lot of businesses, particularly in the manufacturing sector, to look at more automation and technology in order to take away these low-skilled work roles, which kind of doesn't really go with the aim of the of Brexit, but that's the way that it seems to be operating. There have, however, so that was the negative. There have, however, been some changes which have been very, very widely welcome to the immigration rules, and by immigration lawyers and those who sponsor workers to come over to the UK, those businesses that would do that. The aim really is to simplify the immigration rules. Those of you who work like us, who work with it, it is hugely, hugely complex. They are changing all the time. The Home Office website is difficult to navigate, and there has been widespread criticism of the complexities of the immigration rules within the UK. That's something that's been on the agenda to simplify for a while, and it is something that these new changes aim to do. There were a number of different requirements that have now been slightly simplified in a way. Also, in addition to that, those of you who have sponsored workers, migrant workers to come over to the UK in the past, you'll also know that it takes some time to get to the point of sponsoring someone, and they have the changes aim to reduce that period for bringing workers over. Those of you who listen to the radio will have heard the advert that you can sponsor workers to come over within 8 weeks now, and that seems to be the aim of the changed rules. So in terms of other changes, there is now no cap on tier 2 workers. That has been suspended. That means that there's no limit on the numbers of skilled workers who can come to the UK. The Home Office say that this change will reduce the end-to-end process for sponsoring a skilled worker, by up to 4 weeks. In addition to that, the salary threshold, which is subject to the going rate for each role, has been reduced to 25,600. There is a trade in that for those jobs that are on what's called the shortage occupation scheme, or for those PhD students in particular subjects where you can pay a lower salary than the 26,600. I'll come on to that in a minute, how that works. So if you're looking at sponsoring a skilled worker and bringing somebody over, then there are the different requirements that I'll talk about for the points-based system. But so there is no, as I mentioned, there is no route for those unskilled workers, and there are specific exclusions for a lot of different roles. But if you are within that skill level, so the skill level is A level or equivalent, so a job that the skills required at A level or whatever the equivalent qualification would be in their country. So that's the only person that you can bring over to sponsor. But if the role is on the shortage occupation list, which there is a list of that on the government website, then you can pay a lower salary during that time. This occupation list is being constantly reviewed and extended. So they pull together, it's quite difficult to navigate, and Charlotte and I have been on it quite a few times and advised clients on it. There are different codes and things for different roles. They are extending it and reviewing it all the time. I'm working with a client at the moment who is in the process of campaigning to have a particular role added to that, because they say that there is this occupational shortage of particular, well, it's skilled butchers, which sounds quite an interesting role really, but there is there are a shortage of those, so they're campaigning to add that to the list. And if you work within a particular industry and you have industry groups that you can work together to add these occupations to the list, then it's certainly worth looking at. If the job is not on that list, or they're not a PhD student working in a particular area, then you have to pay at least 25,600 in order to sponsor them. Another key change is that under the old rules, there was this requirement for a resident labour market test. You had to satisfy that before you sponsored a worker. So what that meant is that essentially a job needed to be advertised to settled workers within the UK for a period of 28 days before a migrant could be recruited to fill that post. And there were certain requirements about how that role was advertised, and you had to retain evidence of that. However, so that's now been removed, which is obviously going to significantly reduce the reduce the length of time that this is going to happen. I was asked a question in advance of this about what the requirements are now, which was a really great question, so thank you for that. There is still a requirement that sponsors seek to fill a genuine vacancy. So that has to meet the skill and salary threshold of the new role. So roles cannot be created solely to facilitate immigration for a specific migrant to the UK. There is much debate amongst us immigration lawyers at the moment about the particular wording of the legislation surrounding this, because it's clear that the resident labour market test has been removed, but there is still this requirement for the genuine vacancy, and the Home Office can and will ask for information as to how and why an individual has been offered a role. And if they don't consider that this genuine vacancy test has been satisfied, then the Home Office can refuse to grant a certificate of sponsorship to bring the employee over, or refuse an application for a visa. And in addition to that, they could initiate alternative enforcement action. So it's really vital that you hold evidence of this role, I would say, being advertised in any event, and demonstrating that it is a genuine vacancy. I know that there is a couple of recruiters on here as well who will work with international applicants, and they will be vital to this process as well, to enable you to hold that evidence that this was a genuine vacancy and that you had had that there was a requirement for that role as well. So yeah, thank you for that great question on that one. Another couple of changes as well. Most EU citizens will now not need to attend a visa application centre to enrol their biometrics, and they'll instead provide facial images using a smartphone self-enrolment application form. So that's the increased use of technology, which makes things much more straightforward. Also, watch this space. There is a graduate route that they are planning to launch in summer 2021, which students can continue to remain in the UK post-study. The plan is there that for those who have completed a degree at a UK higher education provider, they can stay in the UK for 2 years or 3 years for PhD graduates. I know that we have some higher education providers here on this session today, so you'll be quite interested in that as well. And the plan is for them, those graduates, that they can work at any skill level and that they can switch into work routes if they find a suitable job at that stage. So quite a useful piece of information there. So just a summary of the skilled workers sponsorship requirements. So they call this the points-based system. I think there was a lot of spin and hot air around. Everyone wanted this Australian points-based type system, and we've kind of got it, but it's not quite as flexible as that, because the key point is that there are these mandatory requirements. So in order to sponsor a worker, they have to satisfy these particular requirements. So the first is that there is a job offer from a licensed sponsor. The job offer must be at or above the minimum skill level, as I mentioned, which is the A level or equivalent qualification. This is hard to determine. Is this the right level? What is the equivalent qualification abroad? And I've been asked that quite a bit by those who are looking to sponsor. And then equally, there is the English language requirement as well, that the English language should be spoken to an acceptable standard. So those are your mandatory requirements. And then there are tradable points as well. So in addition to that, one of these should apply. So there are 20 of these required. So the salary level should be at the threshold of the 25,600, or alternatively, whatever the going rate for their particular job is. So when you look at these codes on the website, they have different salary levels of what that going rate should be. So you need to check that on the Home Office website or take advice on that as well. Alternative to that, so if it's not at that level, it should be in a specific shortage occupation. That's the shortage occupation list, or a PhD relevant to the specific job. But overall, the absolute minimum salary requirement is £20,480 per annum. So you either pay more than that, or you have a job offer in a shortage occupation list, or a PhD and you pay the lower amount, if that makes sense. There is also I've not put this in the slide, but I think it's worthy of mentioning. Any new entrants to the labour market are entitled to come to the UK on a 30% lower salary than their more experienced counterparts are required to earn. So that's quite useful as kind of an alternative route. They will benefit from the reduced salary threshold for 3 years. Migrants are they're going to be defined as new entrants to the labour market if they're switching from the student or graduate route to the skilled worker route. So this is the graduate worker route. If they're under the age of 26 at the date of their application, or if they're working towards a recognised professional qualification, or if they're moving directly into postdoctoral positions. So those higher education providers that are on the session today, that's quite useful for you as well, for your PhD students, your foreign PhD students. There is a cost, obviously, associated with sponsoring employees to come over. There's still the immigration skills charge, which is £1,000 per skilled worker for the first 12 months, and then an additional £500 charge for each 6-month period, and that's discounted but for SMEs and charities as well. And then there's your cost of assigning a certificate of sponsorship as well. And then in addition to that, if you don't already have a sponsorship license, there will be the fees for obtaining a sponsorship license, on which more later. So moving on to intra-company transfers. Again, you need a sponsorship license if you're looking at an intra-company transfer. I know that a lot of you that are here today have asked about this. I've had a couple of questions about this specifically. And also Charlotte and I have advised businesses on this in the past. So an intra-company transfer route, that's different from the sponsorship skilled worker route that we just outlined. So this is for larger multinational organisations. Who qualifies here? So this is for migrants who have been offered an eligible job by their overseas organisation to work in its UK branch. So if you have if you have a part of a group structure, that part of it is abroad, and you want to bring somebody over to the UK to work here, then you can use this route potentially. So to qualify, you need to do a job that's on the list of eligible occupations. Again, another part of I wouldn't like to be the person that wrote this website. The Home Office website, there's all sorts of stuff on here, honestly. So that's also on the website as well. You need to be paid at least 41,500 for the normal route, or there is a graduate intra-company transfer route where they can be paid 23,000. I need to just amend that slide. It's not 2,300, it's 23,000 per annum for a graduate trainee. And they need to have worked for your overseas branch for more than 12 months in the normal route, unless they receive a salary over 73,900. And for graduates, it's for 3 months. So the route for the company graduate trainees, that has to be part of a graduate training program for a managerial or a specialist role. And then there's obviously this requirement that you have to have already commenced your graduate role and worked for the overseas arm for a period of 3 months before you can come over to the UK on this type of a visa. So the maximum total stay for an intra-company transfer visa is 5 years in any 6-year period if they earn less than 73,900 per annum, and 9 years in any 10-year period if they're paid more than that. So it's actually quite a relatively long-term visa option for you if you are looking at bringing people over in that way. So moving on to sponsorship licenses and obtaining a sponsorship license. So you can't employ, not basic stuff really, you can't employ non-UK workers under the new system unless you have a sponsorship license. The cost here, I've just outlined that there, is £536 for SMEs and charities, or £1,476 for normal sized companies. It is an online application process, and there is a large number of supporting documentation that needs to be accompanying that. It is a very complex process to apply for a sponsorship license. I know some clients have tried to do it themselves online and have managed to get through that early stage. But what always happens after you apply for a sponsorship license is that there is an audit, and then there is a Home Office visit at some stage as well. And you need to be absolutely ready for that Home Office visit. There are a number of requirements that I'll go through for holding a sponsorship license afterwards. But one of the things that you need to explore very carefully are your internal HR processes, and ensure that those who are involved in working with the sponsorship license understand clearly what the sponsorship duties are. It's very prescriptive from the Home Office what the requirements are for holding a sponsorship license. We always say that a mock audit before you go through this of your rights to work checks, your HR processes, your tracking systems is absolutely vital. That's something that Charlotte and I do for organisations. We help them through applying for a sponsorship license, and then we'll go in and conduct this mock audit. Also, in addition to that, if you have a UK VI compliance visit, you will be expected to understand what the requirements for sponsorship are and what the requirements for holding a sponsorship license are. So having some training on that is absolutely vital as well. And again, that's something that Charlotte and I are and our team are able to support you with. So what is it that you're signing up to? So the main duties and the key duty is the record keeping. The requirements for record keeping are significant and are very prescribed. You need to ensure that you hold things like your sponsorship license application documents. You need to show and demonstrate that your systems can track visa expiry dates, and you've got checks and balances in place for that. Also copies of documents showing right to work checks, contact details and history for the migrants that you hold over, things like national insurance numbers, employment contracts, job descriptions, evidence that you've gone through, that you have a genuine vacancy. Also, in addition to that, clear records of absences as well need to be held, and there are specific reporting requirements, as I've included in there, that through your sponsorship management system, you need to report if there are within certain prescribed days, like 10 working days, if there's any change in circumstances or unauthorised absence or time outside of the UK and things. There are reporting requirements in there. The other main duty is compliance with the immigration laws and ensuring that you understand those. Cooperation with the UK VI as well. There is this baseline that if you are appointed as a sponsor, the Home Office are placing a great deal of trust in you to ensure that the checks and balances are in place, so you must cooperate with them at all stages. Also, as you would expect, as an organisation, that your behaviour and actions are not detrimental to the wider public good as well. And also think about, if you are becoming a sponsor, there are different roles for the sponsorship route as well. So you'll need somebody as an authorising officer. There are key personnel. HR need to be really heavily involved, as you would expect, and your recruiters, if you have internal recruiters or you work with external agencies, get them involved in it as well. Ensure that your IT systems are clear and up to date for tracking, and you have a good HR system that looks at that. So that's all on sponsorship for now. A bit of a whistle-stop tour of what is a very complicated process. And if anybody has any questions on that or wants to understand a bit more about that, then please do give us a call. I'm more than happy to take you through on a specific, your own specific basis, how it might look for you. So I'm going to move on now to the EU settlement scheme, which seems to be the real hot topic at the moment. So the general rule, as I'm sure you're aware, is that EU nationals residing in the UK by the 31st of December can apply for the EU settlement scheme. There are some exceptions for those who were outside of the UK at that date, but who had, for example, historic continuous 5 years residence. They can still apply for it, or also close family members where the relationship existed before the 31st of December. They could also potentially be eligible for applying for that scheme as well. The deadline for applying for the EU settlement scheme is the 31st of June 2021. It is absolutely clear that the obligation on applying for the EU settlement scheme is the employee's obligation. It is not the employer's obligation. So the guidance, the government guidance, emphasises that it is their responsibility to complete this application and to ensure that it's in place by the 30th of June. You are able, as an organisation, to signpost this information and make it clear to your employees what the deadlines are of this and make them aware of that. However, the government guidance provides very stark warnings about the risk of discrimination against EU and EEA and Swiss citizens. That means that you cannot require the employees to show you their settlement status until after the 30th of June 2021. There is also no requirement on existing employees to inform you that they have applied for the scheme or the outcome of the scheme. You will have, and Charlotte will talk about statutory excuse shortly, you will have when the employees started working for you, if they started working for you pre 31st of December, then as long as you've conducted the appropriate right to work checks at that stage, then there is no requirement on you to even ask them for this. Their obligation is on you. You will not, as an organisation, be at any risk for continuing to employ that person. So, and if you do ask for evidence of this, then you could fall foul of discrimination legislation. So, and what I put on there is that there is no requirement for a retrospective request for existing employees. So there is no change to any of the right to work protocols until the 1st of July 2021. So there's this kind of gap. So you've got your employees pre the end of Brexit transition period who are already here. Not so much of a concern with them. the question that I've been asked probably more than anything on the list beforehand is, what do you do with your staff between the 1st of January this year and the end of June? If we employ somebody in this time, what are the requirements for that? And it's a good question. Again, the government requirements are that there is no, candidates don't need to share their status using the online checking service. So you can use your online checking service to confirm that a candidate has that pre-settled or settled status, and therefore have the right to work in the UK, but they don't have to share that code. So you get, those of you who know who've done this in the past, you get like a code, a share code for if you're looking at online checking service. There is no requirement on them to share that. So if somebody if an EU employee is able to show their passport or their identity card, that is sufficient to for your rights to work checks up to the end of June. For those who are employed after the end of June, so anybody that you employ from the 1st of July and onwards, you can at that point ask for evidence, and should ask for evidence, that they have the EU pre-settled or settled status at that point. So the real change comes from the 1st of July. There is a different situation. So there is a duty to prevent illegal working, which sits alongside this. So if you have, if you're recruiting an employee that you are aware has arrived after the 1st of January, they're not going to obviously be able to apply for settled status or pre-settled status. So in those circumstances, they will need a visa in order to work in this country. So if you have any reasonable suspicion that somebody has arrived in the country after the 1st of January in this year, then you can and you should explore it further. But if there is no indication that they had applied after that date, then you can accept an identity card or a passport up to the 30th of June. So hopefully that makes some sense there. So moving on now, it kind of takes us neatly on to Charlotte's right to work checks and the requirements for those.
Thanks, Amy. So on right to work checks, I'm just going to go through some of the basics just to start. I do appreciate that quite a lot of people on the call will already be used to carrying out these checks and do it frequently, but I think it's a good refresher to kind of go over why they're important and obviously explain the statutory excuse that Amy's just touched upon. And then I'm going to go through some of the adjustments to the government right to work check guidance as a result of COVID-19 and obviously increased working from home. And then just touch upon kind of add a bit onto what Amy's just mentioned about the right to work checks for the EEA and the Swiss nationals. So as a starting point, as Amy mentioned, as an employer, you do have an obligation to prevent illegal working and to ensure that employees do have the right to work in the UK. If you are found to have been knowingly employing an illegal worker, there are some large civil penalties, and also there could be criminal sanctions in some limited circumstances. So it's really important to make sure that you get the right to work checks correct at the beginning of employment in order to establish a statutory excuse which acts as a defence to any potential sanction that you might be exposed to. So for a person who has a permanent right to work in the UK, if you carry out a right to work check correctly at the beginning of their employment, you'll establish a statutory excuse for the duration of their employment, and you won't need to carry out that check again. For a person who has a temporary right to work in the UK, so it's time limited, they're not able to remain for the rest of their lives, you'll be required to conduct a follow-up check in order to retain your statutory excuse and to have a defence to any sanction that could be that you could be exposed to if they were found to be an illegal worker. You need to check this just before the permission is due to come to an end. So you'll need to diarise those checks at the very beginning when you do the first check, and ensure that you're doing the follow-up checks later on to make sure that you continue to retain that statutory excuse. In terms of basics, just the steps to carrying out a right to work check. Obviously, the first step would be to obtain an original version of one or more of the acceptable documents. The government guidance, which you can find on the government website, on the Home Office website, sets out 2 lists that have all the different documents that you can accept as proof of right to work. There's list A and there's list B, and depending on whether someone has a permanent right to work in the UK or a limited right, depends on which list that you would use. So you need to obtain an original version. Secondly, you need to check the validity of the document. You need to make sure that it's valid and that it's not a forged document, obviously as far as you're able to, so long as it's not kind of glaringly obvious that it's fake, then you can only do as much as you can. So as long as it looks like it's a genuine document. You need to check that document in the presence of the holder. So you'll need to make sure that that person's in front of you and you can kind of verify that it's them and that the ID corresponds to the person in front of you. And then you need to make and retain a clear copy of the document that you've checked and record the date that the check was made. So we just move on to some of the adjustments as a result of COVID-19, because obviously there's been increased home working as a result of COVID-19. Sorry, Amy, can you just go back? Thank you. So there's been a few adjustments just to make sure that people can still carry out the right to work checks. As I said, that you need to check in the presence of the person. You can now do this by video call and check the documents correspond with their face on a video call on Teams, Skype, etc. And they can just hold that document up and you can check the validity. For the time being, scanned documents will suffice. You don't need the original document, just to kind of avoid people sending them by post. So during this period, you should record that you've made an adjusted right to work check, and you'll have to diarise to do a follow-up check once the restrictions have been lifted a bit, and you can meet with the employee face-to-face and see their original documents. So as Amy mentioned, there's obviously been a few changes to right to work checks for EU nationals following Brexit. And I think there was a question in the chat box about whether if an employee kind of volunteers to show you the settled status document or pre-settled status document before July, whether you can accept that. If an employee voluntarily gives that to you and you've not kind of said that they need to, that's absolutely fine. But you just can't be too pushy and kind of require them to do that at this point in time, because you don't need that document just yet. So as Amy mentioned, until the 30th of June, when the EU settlement scheme application period comes to an end, for anyone who arrived in the UK before the 1st of January 2021, an ID card or an EEA or Swiss passport is sufficient for right to work documents. You don't need to ask them for the pre-settled or settled status document. But for anyone who arrived after the 1st of January, they'll be required to show their visa as proof of right to work in the UK alongside their passport or identity card. And then, as Amy mentioned, from July, you either need a current EEA or Swiss passport or identity card and either a visa or settled or pre-settled status document. Next slide, please, Amy. So as you'll see on the slide, they set out a number of practical considerations to take into account with carrying out right to work checks post-Brexit. So firstly, you might want to consider kind of sending communications to employees and just to the general workforce, reminding them of the need to register for the EU settlement scheme. And you can kind of signpost them to the government website with details of how to do this. This is obviously noted as optional because, as Amy mentioned, it's completely down to the employee. It's their obligation to make sure they apply for this scheme. But I think it can help maintain good employee relations, and it can help you to retain staff who might not have been aware of the requirements, and they might just think that their right to work in the UK will automatically continue, which isn't the case. So just to make sure staff are aware, just make sure you're not too pushy with it and make sure, like saying that they need to do it, it's obviously their choice. Secondly, you need to make sure that anyone involved in HR or recruiting new members of staff are aware of the new right to work documents for the EEA or Swiss nationals, and that anyone who's entered the country from the 1st of January will need a visa and a passport and ID card, will not always suffice. And just make sure that HR teams and systems that you use are ready to be able to track more employees and keep an eye on their right to work as well. I've put to kind of diarise some follow-up checks in June or July. This is optional. Obviously, you need to make sure that you're carrying out further checks, but you don't want to, as Amy mentioned before, you can't single out just EEA or Swiss nationals and just make sure you go through their right to work checks. If you do want to kind of have a look overall, you should kind of audit your whole workforce and make sure that the right to work checks are correct across the board, just to make sure that there's no element of discrimination there and it doesn't look like you're purposely targeting just EEA or Swiss nationals because you think that their right to work might not be valid anymore. And then we just put, be alert to knowingly employing someone without valid immigration status. If you do find yourself in this situation following when you audit your right to work checks, where you've got someone who may not have the right to work and you're looking at maybe terminating their employment, we would advise that you do come to us for some advice on this, as we have advised a few clients recently, and it can be quite confusing, it's quite complicated. You'd think it'd be quite straightforward and you could kind of just dismiss, but it wouldn't be a fair reason if you did do that. You need to make sure that you have solid evidence that that person doesn't have the right to work, and just because they don't have the right documents doesn't necessarily mean that. So I definitely advise that you come to us if you are in that situation. I'm going to move on now and talk about business travel.
Just before you do that, Charlotte, just to pick up on a couple of points there. It's important to be aware that if you knowingly employ somebody without a valid immigration status, that it is a criminal offence, and that there not only are there significant fines, there's also potential for imprisonment as well in those circumstances. So and knowingly is quite complicated. You know, there could be a situation where somebody discloses to you that they arrived after the 1st of January, and it doesn't, well, not necessarily to you, but somebody within the HR team, and they don't really join the dots and realize that they need to provide evidence under, you know, that they have a visa during that stage, and they wouldn't be they wouldn't necessarily be entitled to apply for the EU settlement scheme. If that happens, even if it's a mistake, there is that potential for that significant liability. And the case so Charlotte and I dealt quite recently with a case where there was a suspicion that an employee didn't have, well, we dealt with a few of these, where there's been suspicions that employees didn't have valid immigration status because they've not been able to produce the right documents. And there was one situation that we dealt with where there was clearly no right to work, so the employee was dismissed immediately. The other one, well, actually, the employee was going through an application process, and so there was a valid statutory excuse to continue to employ that individual. The problem here is that, so with a normal dismissal, you have to have a reasonable belief in if it's misconduct or something along those lines. For a dismissal that relates to the loss of a right to work, so that would be an illegality type dismissal, you have to have actual evidence. It's not reasonable belief, it's actual evidence. So there is a much higher burden for that kind of situation as well. So that's why we say it's so vital to take advice. The other point as well, as Charlotte mentioned, is that what a lot of the clients that we're working with, because there is understandably this concern about, well, you don't need to know about, employees don't need to provide you with their evidence of the EU, that they have EU settled status or pre-settled status. But there is this concern, and I fully understand that whether you are complying with your obligations. So the majority of clients that we're working with that have this concern are doing a full audit of all, and Charlotte mentioned this, of all of their right to work checks after the 1st of July. We've been getting involved in that as well. We can come in and do specific training for the HR teams on right to work checks for your organisation, what that might look like. And then also we can get involved, and we are doing audits and looking at your systems that you have in place to ensure that you're compliant going forward. But by doing that, you can ask for everybody you can recheck everybody's right to work status, and therefore there is much less risk of any kind of discrimination. So sorry for jumping in there, Charlotte, but I thought it was interesting to share some of our experiences with clients recently to kind of put it into context. So yeah, back to business travel.
I'm just going to briefly touch on business travel because I know we've only got 15 minutes left. But this is quite an important area that obviously will affect quite a lot of companies whose business does involve regularly sending employees to the EU, or they might be bringing employees over from the EU to work in the UK. But obviously, as a result of Brexit, UK nationals no longer have an automatic right to work in the EU. And similarly, EU nationals who want to come over to the UK no longer benefit from that right either. So obviously there are some limitations now on how often you can come over, the activities you can carry out when you are over here or in the EU. So as you can see from the slide, UK business visitors to the EU are subject to stays of 90 days in an 180-day period. And I'll go on further to talk about the type of activities that they can carry out while they're there. This is for visa-free travel. And then EU citizens can visit the UK and stay for up to 6 months, and they can participate in a wide range of activities, including business-related activities such as meetings, events and conferences. And they can enter the UK multiple times during that period, but they can't use that as a way of living in the UK, like using frequent and successive visits to try and live in the UK, but they're able to come over here a bit more frequently. But yeah, there's obviously quite a lot of limitations now on the types of activities you can carry out without needing a visa. I think it's also important to note, because this is something that shocked me, to be honest, that personal travel and business travel will be tracked cumulatively. So if someone's working coming from the UK, going to work in Germany, and then they go on holiday there for 2 weeks, that will also be counted in the 90 days and the 180 period. So really need to be careful on where employees are travelling to, and if it's somewhere that they need to travel for business as well, you need to make sure that you're taking that into account, because you want to avoid them going to travel for you and ending up stuck at the borders and not being able to get there. So it's important to kind of keep track of that without being too intrusive of where they're going and what they're doing. But it's important to kind of bear that in mind, because I was quite shocked at that, and I think there should have really been allowances made for personal travel separately, but that's where we are. So I'll move on to the next slide and just talk about some of the activities that can be undertaken when you do go to the EU, when you do send workers to the EU. So as you can see from the slide, there are limitations on the type of activities that can be undertaken in the EU without having to have a visa. These vary per country in the EU. There's no standard position for the whole of the European Union. It's different depending on which country you're going to. So what we need to focus on really when we're kind of advising on this to clients is the activity that the person is going to the EU for and what they'll actually be doing during their stay, because that's what will be looked at when you need to determine whether a visa is necessary or not. So obviously there's no set position across all of the European Union, but the general rule is that in that 90 days in every 180-day period, the general rule is that business meetings can be carried out. You can monitor emails from your phone. You're not able to do any productive work. No on-the-job training, no hot desking, no project delivery or report writing. And then it says audit work may be limited or prohibited. So it's not too clear at the moment whether you'll be able to carry that out. If it falls outside of these exceptions, you will need to get a visa, and you'd need to apply for that based on the country that you're wanting to travel to. Sometimes it could be the case that there isn't a suitable route to obtain a visa to work in an EU member state, because there might be, as there is in the UK, salary and qualification requirements that you might not be able to satisfy for an employee going over there. And also the visa applications can be quite time sensitive and costly, so you might decide that it's just not worth it. So it's important to think about this every time you are thinking of sending an employee over to the EU for a work activity, and kind of decide whether you think it is kind of worth it. So as I've mentioned before, the visa requirements are different for each EU state. Some are quite stringent that me and Amy have seen. We advised a client quite recently. They had a few questions on a few different member states. I think there was Sweden, Finland and Norway. So we'd had a look at the requirements, and we found that Sweden seemed to have quite stringent requirements for the visas over there and to get a work permit. So it's just important to bear in mind, because there was an obligation on the employer to kind of consult with trade unions over there in the relevant field, and then there was also advertisement requirements. So the time period that it would have taken to be able to even offer an employee a position to come over there and kind of to work there it wouldn't have been worth it for the employee for what they needed them to do. It would have taken far too long, and it would have been too costly, and there was an possibility that they wouldn't have been able to do it at all. This won't apply if you're sending someone over who already works for your company and you've got another branch in the EU. There's different requirements then, and the advertisement requirements, as I've just mentioned, for Sweden wouldn't have applied. But it's just important to bear in mind that there's different requirements for each country, and there's not kind of a blanket rule, so it's made it quite difficult to advise on now. But it's just important to keep that in mind when you're sending employees over to the EU for business travel.
Thanks, Charlotte. Just to kind of add to that as well, we were aware of a client who had a situation where very recently employees who were travelling for business purposes were stopped at the border and very heavily questioned in relation to the purpose for their travel. The key point here is that if you are sending your employees, your UK employees abroad under this permitted business travel requirements, so you are, following the general rules and you don't feel that they have a visa, that you actually brief those employees properly in advance about the reason for their travel. And also, I would say that you have you prepare a letter from the business explaining exactly what they're going to be doing. These particular employees, it was very uncomfortable, very difficult situation to be stopped at the border. Nobody wants that to happen. And those individuals, those employees felt very unprepared for that. So in any kind of business travel, just make sure that HR are briefing those people about what might happen at the border, and that they're fully aware of what kind of questions they might be asked and how to deal with those. Having a letter and having something confirmed is really vital. The other thing as well, just to finish up on this, we haven't mentioned frontier workers. So you may have heard about this frontier worker permit. Again, that's something that's going to apply after the 30th of June. So you can apply for a frontier worker permit to come to the UK if you are an EU citizen who lives abroad but regularly travels to the UK for work purposes. You need to be able to demonstrate, however, that you have worked in the UK before the 31st of December 2020, and then you keep working in the UK at least once every 12 months since you started working here. So these permits enable people to travel to the UK if they're based abroad, based within the EU. The permits are valid for 5 years for those who are workers or self-employed, or potentially 2 years for those with retained work or self-employed status. So, and this is going to be some kind of digital process, and it's also free. So just to kind of wrap up on that, if anybody's got any specific questions on frontier workers, please do let us know. So we now have a little bit of time for questions. I'm just going to have a quick look in the Q&A. I think we've dealt with the majority of these. I've just had a question from David, just to say, is this typically via embassy? I think I'm not sure what you mean there. I think potentially you mean the visas for business travel. If somebody needs a visa to travel abroad, the answer to that is yes. It would usually be via their embassy or whatever their equivalent version of the Home Office is over there. There's often online application processes for obtaining worker visas for foreign countries as well. So if anybody has any more questions, pop them in the Q&A, pop them in the chat. I'm going to pull out a couple of questions that we had. I had a really good question from Jeff at Hayes, who obviously works in the recruitment side of things, and he asked about the minimum salary requirements for sponsorship of workers and whether there's any potential appetite for those to be reduced, which I thought was a very interesting question. I would say no at the moment. I think we'll have at least 12 months of working with the rules as they are, as they currently stand. But what we will see is an expansion of the shortage occupation list, because I know that this is providing challenge for a lot of the clients that we work with about who's on this list and who isn't. And if they are on that list, then you can pay them that lower salary, that just over 20,000 salary as well. We also had a question that relates to, in relation to EU nationals and recruiting them, would it be advisable for any EU national to sit an English language test, even if they are remotely contemplating working in the UK, as opposed to waiting for a job offer? I would say yes, certainly, not necessarily an English language test, but they need to ensure that they are comfortable and confident that they will pass that English language requirement. So if you're working with an individual who wants to look at a placement, then ensure that they have that they are working towards that, because that is a clear compulsory requirement. So the other question as well, there was another question there that related to genuine vacancy requirements might cause the Home Office to regard with suspicion small companies who want to recruit family members who are not dependents. Absolutely. There needs to be some evidence there that it is a genuine vacancy, and there will be some scrutiny of that as well. We were asked about the status of HMRC Form A1. That's more of a kind of tax question that relates to social security benefits of people who move and work within the EU. Again, I think we'll be looking at frontier worker status there for that. I was asked a very interesting question about a French ambassador who's potentially coming over. That's one that we'll take offline because I think it's quite a specific situation and probably something that we'll need a bit of confidential advice for. Back to the Q&A. Is it possible to apply for a visa without full confirmation of where the employee will be placed for which client, although the skill base and role will remain the same? I think that would be quite challenging to do that. You would need to have a very specific role and ensure that you have you've complied with all the eligibility requirements if you're looking for a skilled worker visa. In terms of an intracompany transfer, there is still this requirement for a genuine vacancy to be in place. So I would say that you're more likely to be knocked back if you don't have full confirmation of the detail of the role and the post during that time. So once we employ a candidate for a particular role, can we then move them between areas in the business or into different projects if the skill core duties remain the same? If so, how does this require a sponsor note? That's a really good question. So one of the things that the Home Office are very hot on is that you upload to your sponsor management system and you retain copies of contracts of employment and job descriptions, and the role should remain within that. So if you are if you have employed somebody in a particular role, you probably want to ensure that the job description is wide enough to cover that kind of situation. If the skills and the core duties remain the same, then you're unlikely to be at any particular risk there. But if you have some concerns and the role does change, then absolutely I would note that in the change of circumstances on your sponsor management system. There is this 10 working day requirement to notify of any significant changes, so that would be one of those, I would say. And then we've got lots of questions here, so I'll just take a couple more. Do you have a view on screening questions on an application form for a role? Please confirm your eligibility. That's an interesting question, David. So if you are asking somebody to apply for the role, normally you would say, please confirm that you have the right to work within the UK. That would be a standard question, and absolutely you can still include that up to this stage. You just can't ask for somebody of evidence that they have settled or pre-settled status up to the 30th of June. After that, then you would be asking for evidence that, do you agree with that, Charlotte? After that, you would be asking for evidence, specific evidence that anybody that they have settled or pre-settled status. Do you agree with that, Charlotte?
Yeah.
Great. So we've had I've had a question about a particular specific situation. We'll deal with that one offline. I think I don't want to go into specific situations at the moment. Just keep I will speak to you, Sonia, afterwards about that one. If anyone's got on any more general questions, then please let us know. But otherwise, thank you so much for joining us today. I know that I've probably bombarded you with information, and I've bombarded you with information. There is a lot to go at here, and it is very complicated. But the good thing about immigration is that it is very procedural, and it is very, you know, and a lot of this stuff is very clearly dealt with by the Home Office. So you've got our details on there. Please do get in contact with us if you have any extra questions, or if you want to discuss specific requirements, or if anybody wants to look at an audit and things as well. That's something that we can absolutely do. We do have a specialist team here who we can assist you with a wide range of immigration inquiries. I think Christy's about to launch a poll. The feedback that we get from these sessions is really vital, and it does enable us to put on sessions that people, you know, we put this session on because people had specifically asked about this in the past, so please fill it in. It's very useful for us. And for those of you who are looking at business travel, or looking at kind of working with foreign workers, with migrant workers going forward, all the best with that. And you know where you are if you need anything else. So thank you, and I hope you all have a lovely day.